Hanging is the method used to execute the death penalty in Japan. After being blindfolded, the condemned prisoner is forced to stand on top of a trapdoor, and a noose is placed around his or her neck. Then the trapdoor is opened, leaving the prisoner's body suspended approximately 30 centimeters off the ground. The method by which judicial hanging is carried out was determined under the Grand Council of State Decree No. 65 in 1873. Though some aspects have changed, the system has essentially remained intact for approximately 140 years. But doesn't judicial hanging, carried out in this manner, violate Article 36 of the Japanese Constitution, which forbids the use of cruel punishment? The death penalty is one of the oldest forms of punishment in human society. It can be traced back through history to customs such as making human sacrifices to the gods and acts of blood vengeance that were practiced in ancient societies. Every country in the world has employed the death penalty at some point in its history. It is something that has been a part of human history since ancient times. At a certain point in history, criminal punishment, including the death penalty, grew increasingly inhumane. With the rise of samurai society in Japan in the 11th and early 12th century, came a move toward more radical means of punishment. In addition to beheading, hanging, and crucifixion, the death penalty was enforced using newly introduced methods such as skewering, sawing, and tearing the convict's body apart with bulls or wagons. The primary objective was to make the condemned prisoner suffer and submit to authority. To this end, the most cruel means of execution were adopted. But in time, history began to move away from this type of approach, and people became more aware of human dignity. This produced a need for less cruel forms of punishment and execution. In Japan, a gradual easing of punishment occurred between the end of the 16th and late 19th centuries. Then came the arrival of the Meiji Period in 1868. This period became known as the modern era, and a greater emphasis came to be placed on civilization. The government set out to abolish cruel forms of punishment. Under the temporary criminal code that was promulgated in 1868, 6 methods of execution were stipulated by law: hanging, self-imposed throat-cutting, exposure, beheading, crucifixion, and burning. In 1870, with the promulgation of a new criminal code, the number of methods was reduced to 3. The new criminal code centered on a pole style of hanging. This approach called for the condemned prisoner to stand in front of a post, a rope to be placed around his or her neck, and weights to be applied from behind. But as this method inflicted an extreme degree of suffering on the prisoner, it was replaced in 1873 under Grand Council of State Decree No. 65 with a gallows style of hanging, which is believed to have been based on a British model. In the so-called former criminal code enacted in 1880, hanging was established as the sole means of execution. Later, in 1907, a new criminal code was promulgated, but as with the former system, hanging was stipulated as the only means of capital punishment. The criminal code that was enacted at that time is the one that remains in effect today. What is the history of criminal punishment in Europe? With the arrival of the modern era, great changes were made in the existing system, which had been in place since the Middle Ages, known as the era of capital punishment. The scope of the death penalty was gradually reduced, and a move to use the least cruel means of execution began. England, for example, once employed the short drop method of judicial hanging, in which the distance of the drop was approximately 30 centimeters. But as the actual process of strangulation was slow, this method prolonged the condemned prisoner's suffering. This prompted the adoption of a long drop method, in which the distance of the drop was increased to approximately 2 meters. This method was subsequently adopted by many other countries, including Japan. In the United States, judicial hanging was also widespread, but by the end of the 19th century, the method was called into question on the grounds that it was a cruel punishment. In many U.S. states, this prompted a shift away from hanging to the electric chair. But it gradually became clear that the electric chair was also a cruel method. At present, most U.S. states have also done away with this method. In the EU, the death penalty itself has been abolished. Of the countries where the death penalty is still in use, those that continue to use judicial hanging are on the decline. According to Amnesty International statistics, death sentences were passed in the following countries in 2010. Of these, only the countries displayed on the screen implemented the death penalty using judicial hanging in 2010. Hanging is the sole method of execution in Japan. As previously mentioned, this method was established in 1873 under Grand Council of State Decree No. 65. The decree stipulates that hanging will be carried out as follows. In conducting a judicial hanging, the condemned's hands will first be tied behind his or her back, and their face will then be covered with a piece of paper. They will then be made to mount the scaffold and stand on the trap door where their legs will be bound together. Next, a noose will be placed around their neck at a point that corresponds to their throat, and the metal ring securing the rope in a round shape will be placed behind the condemned's head and pulled tight. Next, the trap door will be quickly opened by pulling the gear wheel, and the condemned's body will be suspended approximately 30 centimeters above the ground. After roughly 2 minutes have passed, death will be confirmed, the rope removed, and the condemned's body will be taken down. This is a diagram of the scaffold that was used in 1873. The two-floor structure was approximately 2.7 meters high, and the condemned prisoner's body was suspended by dropping it down to a point about 30 centimeters above the surface of the ground. In other words, the long drop method made use of a drop of about 2.4 meters. Several revisions were later made to Decree No. 65. 1. The execution mechanism was changed from one that could accommodate 2 condemned prisoners simultaneously to only 1. 2. The drop, which had previously been from the second to the first floor, was changed from the first floor to the basement floor. 3. The material used to cover the condemned's face was changed from paper to cloth. 4. The 2-minute period from the beginning of the execution process to the time the rope was loosened was changed to 5 minutes after the condemned was confirmed dead. There are no legal statutes that might form the basis for these changes other than the time of confirmation of death. When, who, and under what jurisdiction these changes were made remains unknown. Moreover, concrete aspects, such as the method of determining the length of the rope, were not established on the basis of any law or decree. The question of whether judicial hanging, as performed in the method described above, violates Article 36 of the Japanese Constitution, which forbids the use of cruel punishment, has been addressed in several court cases. On March 12, 1948, the Supreme Court ruled that the death penalty is not a cruel punishment. Then, on April 6, 1955, the Supreme Court ruled that judicial hanging is not a cruel punishment. Yet in both cases there was no examination of evidence related to the execution of judicial hanging. In a separate case, 3 written expert opinions were presented in the Tokyo High Court. One of these was a statement by Professor Furuhata Tanemoto, a noted forensic pathologist. It is thought that Furuhata's opinion formed the basis for the 1955 Supreme Court decision. His 1952 statement explaining judicial hanging from a forensic perspective contained the following description. When a rope is placed around the condemned's neck and the weight of their body is suspended from it, the left and right carotid arteries and both vertebral arteries are completely compressed in persons with a weight of 20 kilograms or more. Their weight is applied to their neck, causing them to instantly fall into a stupor and completely lose consciousness. Thus, it is common knowledge in forensic medicine that a typical hanging is the most painless and merciful way to die. Assuming that hanging is executed in the most ideal manner, it can be seen as superior to other methods of capital punishment, in the sense that the corpse is not damaged, it does not inflict pain on the condemned, and it does not leave us with a sense of posthumous cruelty. In short, Furuhata's opinion asserts the following 3 points in regard to hanging. 1. The condemned convict loses consciousness instantly. 2. The convict's corpse is not damaged. 3. Hanging is the most painless and merciful way to die. Was Furuhata's opinion correct? Research conducted by Dr. Walter Rubbel proves that Furuhata's statement was medically inaccurate. In addition to serving as the deputy director of the Innsbruck Institute of Forensic Medicine, Dr. Rubbel is the president of the Austrian Society of Forensic Medicine. He has amassed a large body of research over his 30-year career as a forensic scientist. Prompted by his investigation of a 1994 incident in which a suicide victim was decapitated, completely severing their head from their body, Dr. Rubbel began studying what sort of effect hanging, whether as a means of suicide or capital punishment, has on the human body. Research on suicide cases numbers between 15 and 20 annually, with a total of approximately 300 studies conducted over the years. This makes Dr. Rubbel one of only a handful of researchers in the world who is active in this field. According to Dr. Rubbel, in medical terms, there are 5 possible causes of death in judicial hanging. The first is asphyxia, oxygen deprivation, caused by compression of the cervical veins and arteries. The second is suffocation caused by occlusion of the pharynx. The third is decapitation, in which the head is severed from the body. The fourth is compression of the medulla oblongata, caused by displaced cervical fractures. And the fifth is acute cardiac arrest, caused by an injury to the vagus nerve. The order of the 5 causes is based on the probability of occurrence. Let's take a closer look at these 5 causes, starting with asphyxia caused by compression of the cervical veins and arteries. The first cause is asphyxia, oxygen deprivation, caused by compression of the cervical veins and arteries. This diagram shows the blood vessels leading to the brain. The blue lines represent the veins and the red lines the arteries. When the neck is compressed, the veins and arteries are closed off, preventing blood from traveling to and from the brain. Over the next 5 to 8 seconds, the residual oxygen in the brain is exhausted. This causes the brain to stop functioning, leading to a loss of consciousness. If the supply of oxygen is not resumed, the brain cells will die. About 3 minutes later, the brain will suffer crucial and irreversible damage, and after 5 minutes, it will die completely. After the brain dies, the heart will stop. Even if the flow of blood in the 4 blood vessels in the neck were to completely stop the instant the condemned was dropped and the rope tightened around their neck, Dr. Rabel explains that the convict retains consciousness for a period of at least 5 to 8 seconds. Thus, even in a case like this, Furuhata's claim that the convict instantly loses consciousness is inaccurate. Moreover, it is impossible to concretely or completely predict the amount of time it will take for someone to lose consciousness in each specific instance of judicial hanging. The second cause is suffocation caused by occlusion of the pharynx. When we breathe, air passes through our nose and mouth and enters our windpipe. It then travels into our lungs. But when the neck is choked with a rope, the pharynx, part of the throat, is compressed and pressed against the bones, occluding the windpipe and cutting off the flow of air. When the supply of air is stopped, suffocation occurs. In the event that some oxygen remains inside the body, consciousness can be maintained for 1 or 2 minutes, but will be lost shortly thereafter. After 5 minutes, brain death occurs, and as a result, the heart stops. According to Dr. Rabel, people can normally hold their breath for 1 to 2 minutes, and those who practice holding their breath can remain conscious for about 5 minutes. During this time, they can, of course, still experience pain and suffering. In the third cause, decapitation, the head is severed from the torso due to an extreme amount of force exerted on the neck. This, of course, results in death. According to Dr. Rabel, in medical terms, it remains unclear whether or not the subject loses consciousness immediately after decapitation occurs. What is clear, however, is that this directly refutes Furuhata's claim that the corpse is not damaged. In Japan, the case of a female convict named Onozawa Otowa can be used as an example of partial decapitation in judicial hanging. In 1883, the rope bit into the condemned's skin, causing her head to be partially severed from her body during the execution. This incident was reported in a number of newspapers at the time. An article from the Yomiuri Shimbun newspaper, for example, said, "As soon as the trap door in the gallows opened, Onozawa's body dropped straight down from a height of just over 3 meters with the rope around her neck. Perhaps because she was overweight and her body was heavy, her neck was torn nearly in half and blood poured out from that area. After about 5 minutes, she was completely dead and the rope was removed." It is difficult to make a connection between this scene and what Furuhata described as the most painless and merciful way to die. The fourth cause is compression of the medulla oblongata, caused by displaced cervical fractures. These are the cervical vertebrae. The spinal cord passes through the neck and connects to the medulla oblongata. When the vertebrae are broken, the bone fragments may become disjointed and compress the medulla oblongata, causing injury. When this occurs, the entire body is paralyzed and breathing becomes labored. First, the subject loses consciousness, then the brain dies. This in turn causes the heart to stop. Dr. Rabel explains that the only case in which the condemned instantly loses consciousness is one in which a vertebral fracture damages or compresses the medulla oblongata. But this only occurs in very rare cases. The fifth cause is acute cardiac arrest caused by injury to the vagus nerve. Emanating from the brainstem, the vagus nerve controls the function of the heart and digestion. When the vagus nerve is excited, the pulse slows. When violent external force is applied, the nerve becomes excessively excited, causing the heart to beat extremely slowly and eventually stop. This, in turn, prevents oxygen from going to the brain, and the subject loses consciousness in 10 to 12 seconds. After 5 minutes, the brain completely dies. Consciousness is not instantly lost in this case either, highlighting another error in Furuhata's argument. According to Dr. Rabel, stimulation to the vagus nerve that is violent enough to stop the heart is an extremely rare occurrence. We have presented the 5 causes of death associated with judicial hanging in the order in which they are most likely to occur. It is important, however, to point out that there is no way of choosing a particular one in the course of executing a judicial hanging. Until the punishment is actually carried out, there is no way of knowing what might happen, and no one has the ability to predict the outcome. There is no means of preliminary control that can ensure death will occur in the way that we wish. As a forensic scientist, Dr. Rabel has provided us with a clear explanation of what occurs in a judicial hanging. But at the same time, it has also become clear that there is no means of controlling what might happen during a hanging. Let us turn next to 2 incidents related by Professor Emeritus Tsuchimoto Takeshi, a former public prosecutor who, after retiring from the Supreme Public Prosecutor's Office, served as a professor at the University of Tsukuba and a visiting professor at Leiden University in the Netherlands. The first incident was connected to an exchange Professor Tsuchimoto had with a condemned prisoner. Still a young public prosecutor at the time, Tsuchimoto hated crime and was deeply convinced that brutal crimes should be severely punished. In one robbery and murder case, Tsuchimoto expressed the opinion, as the investigating prosecutor, that the accused should be given the death penalty. In the trial, the suspect was in fact sentenced to death, but Tsuchimoto subsequently began receiving letters from the man. The last letter was written the night before he was scheduled to be executed. Through these letters, Tsuchimoto started to question the idea of executing someone who had the potential to change. The second incident, which happened later during his time at the Supreme Public Prosecutor's Office, was related to actually witnessing a hanging. Along with the unnerving experience of watching the condemned prisoner burn incense for himself and receiving a posthumous Buddhist name while still alive, Tsuchimoto came into contact with the man's shoulder, feeling the warmth of his body as a sutra was being recited for him. Then a loud sound reverberated through the space, and when the curtain opened, he saw the man swinging back and forth from the rope, handcuffed and with his legs bound together. This sight made a strong impression on him. I couldn't bear to look, and I thought that there could be nothing more atrocious or cruel. Judicial hanging is on the verge of disappearing from the world. Of the nations participating in the G20 summits that have been held so far this century, only India and Japan continue to use judicial hanging. And India has only carried out the punishment 3 times since the beginning of this century. In the past, we lived in a world ruled by the principle of an eye for an eye, a tooth for a tooth. But over the passage of many years, there has been a shift away from the use of cruel means of criminal punishment. Acts that inflict terrible harm on others are no longer punished with acts of cruelty. This is the direction in which human history has moved.